this meeting to order at 1:10, and we're late because of Mr. Buzzer. No, not really. Ms. Fulbright, would you do the honor of being a
Yes, stand Dear Heavenly Father, we have so many blessings to be thankful for, things that you have blessed us with, too numerous that we can account for. We ask you to give us guidance in our meetings today, give us civility. May we remember the golden rule in all things that we do. Just continue to watch over and guide us, and we give you the praise. Amen.
Thank you, Ms. Fulbright. Roll call.
Meredith Fraley.
Here.
Bill Anglin.
Here.
Sylvan Baker.
Here.
Jack Baker.
Here.
Harley Buzzard. Julia Coates. Bradley Cobb.
Aye.
Joe Crittenden.
Here.
Jody Fishinghawk. Janelle Fulbright. Here. Don Garvin. Chuck Hoskin Jr.
Here.
Tina Glory Jordan.
Present.
Curtis Snell.
Here.
Chris Soap.
Here.
David Thornton. Tara Cowan Lawrence. We do have a quorum.
We have a quorum. We have another long agenda today, so we'll limit reports to 2 minutes and the items to 3 minutes. Next order of business is approval of the March 31 regular session.
So moved. Second.
Moved in second. Any discussion? All in favor, signify by saying aye.
Aye.
Opposed, same sign. Minutes stand approved as written. Okay, our first report is Ms. Wright, Marshal Service. You have 2 minutes, Ms. Wright.
Well, I've submitted my report so I can answer any questions that you may have. That'd be quick.
Do you have any questions for Ms. Wright? It's not. Thank you.
Thank you.
Ms. Hammonds, Attorney General. Good afternoon.
Good afternoon, Madam Speaker. Thank you. The only 2 major items that I'd like to add to our report happened since we got the report in. We filed the brief of appellant in the Nash case, the Friedman case in tribal court on Monday, and I sent your attorney a copy of that. And we believe we have, keep your fingers crossed, another, we hope this one pans out, test case on our hunting and fishing rights, and that this one's going to be in Cherokee County. Other than that, I'll answer any questions, or I'll attempt to.
Hi, Lori.
Diane, what have you done about that case that was adverse to us on the Indian Child Welfare?
10th Circuit
It was dealing with the
Newborn Act.
newborn. We don't have them signed up, but we were counting them as members, and the court said, no, you can't do that.
Correct. Chrissy Nemo was the attorney handling that, and if I get it wrong, she can jump in here. We filed for petition for rehearing and rehearing en banc with the 10th Circuit. They requested the other side to respond, which we took as a positive sign. You know, they don't have to do that. So, and we haven't heard anything yet, correct?
They have until Monday, the adoptive parents have until Monday to file their response.
Will you start including that in your report,
Sure.
just so we can keep it updated? That's a pretty important case for us.
It affects other tribes too. There are, I think, 2 or 3 other tribes who have similar, although not identical, sort of
It's
citizenship.
essentially our only way of protecting the newborns from, that's the way they were getting around the requirements when the Indian Child Welfare Act first came out, was they would just take them in front of a judge immediately and say they're not Indian because they're not members. Well, they're brand new kids, so seldom if ever were they members.
Exactly.
Time's up. Ms. Hammonds, hear that little tune? Thank you.
Thank you.
Is anyone here from the Election Commission? We do have their report in the room. Okay, Ms. Swepson, Tax Commission.
Afternoon.
Afternoon.
I think you do have my report. The only thing I have to add to that is there has been a second employee added at the Collinsville office. So I know there's been lots of questions about that. She is there and working, so there are 2 agents back at Collinsville. I'll try to answer any questions if you have any.
Anyone have any questions for Ms. Truxton? Very good, thank you. Thank you, Sharon. Right along. Ms. Hanby, self-governance.
Good afternoon.
Afternoon.
Just a brief update that we completed all of the Recovery Act reports that we're doing through March. We also received the 102477 program review back, and we had completed that as I reported previously. There's no findings, but and it was a very good review, and we received the actual document back, so.
Good deal. Any comments or questions, Ms. Hanby? Thank you, Vicki. Mr. Hummingbird, you graced us again with your presence. Thank you.
I'm glad you get to see me.
Uh-huh.
I believe my report actually made it into this month's book, so check mark for that. I have nothing new to add, but we'll be able to answer any questions you might have.
Questions or comments for Mr. Hummingbird? Lori Gordon?
Are we still requiring, Jamie, a gaming license for everyone that's employed with C&E?
Yeah, all casino employees, regardless of their position, are required to be licensed by the commission.
I understand that some tribes do not require everyone to have a gaming license, especially if they're working in the kitchen, working in maintenance, working at some of the supportive positions that do not require them to interact in any way with gaming issues.
Okay.
And that a lot of our folks are not being considered for employment over there because other people are applying from other states that have gaming licenses already. Is that true?
As far as the outside people coming in from other jurisdictions, we do have some of those, but I wouldn't say that there's a lot. The primary ones that we see in those cases are dealers that come in for tournaments. If they have a large World Series of Poker or other type of tournament where you expect a very large crowd, they'll bring in some extra board dealers.
Is there a valid reason, though, for those supportive staff positions to be required to have a gaming license?
Yeah, this is a question that we posed to the NIGC several years ago, and they actually wrote back to the commission stating that it is a requirement for us to do a license for all casino employees. However, the background investigation requirements that they have within their statutes are applicable only to certain individuals.
Well, she's going to cut you
Okay.
off.
I can write you up an
If
explanation
you
for
would,
that.
I would like that.
Okay.
Mr. Baker had a question. Can you write up something for him also?
Definitely.
Take your time's up.
Just everything, no. See if there's any leeway or temporary license or waiver or something. Apparently our day work people that they're trying to get in at Catoosa and some of the other places, they're running into roadblocks. And it's a training program. And they're running into roadblocks that they're having to fill out 14 pages and apply for a gaming license to get $50 a day for a short period of time.
May I do short answer? And I'll give him the long answer?
Real short.
Real short. The commission's already voted and taken action on that to provide a much more expedient process for those individuals, and we don't charge for the license, and the background is very quick. We will be shortening it even further with a shorter application very soon. But I'll get you the long answer on that.
I'm sorry, it's long.
Yeah. Thank you.
Thank you.
Mr. Hembry.
Yes, on codification,
Yes.
I met with Mr. Morton yesterday and spoke with the Westlaw people. They're awaiting our combined version of the formats from the IT people, which I'm assuming is going to be upon us very quickly. On another note of a matter on further on down the the agenda. You have a memorandum from me concerning the constitutionality of other acts on being constitutional as to a quorum being present. And this was at Chief Smith's concern. I did a thorough record of every act passed from 95 to 99. That is the only act that was passed without a quorum. It would automatically be unconstitutional because of the passage of the 1999 Constitution. Speaking with Secretary of State Knight, she did find another resolution that was passed during that time, and I will let her address that. But one resolution, one act passed during that time, and the act is automatically unconstitutional because of the passage of the 1999 Constitution. And with that, that's my report on codification.
Any questions for Mr. Hembry? Thank you, Todd. Okay, Mr. Justice, you're here to report a registration citizenship update. Thank you for being here.
Well, I believe you were given a handout showing some of the monthly updates that we've pulled together. On the very last page, I'd like to point out a map that shows that one there, that shows the differences between our geocoding results from previous redistricting attempts to some new data that we've recently acquired now. So we are making some progress, getting a little bit better. We hope that the map looks even better than that by the time the next redistricting happens.
Thank you. Ms. Kalmowitz?
Thank you, Madam Speaker. It references in there that we'll be ready for the 2013 elections, but we have to be ready like in the next 6 months to a year to potentially redistrict or reapportion for the 2013 elections, not be ready in June 2013. So are we tracking for this earlier date, or are we tracking for June 2013?
We're tracking for the earlier date.
Okay.
We're hoping to be there.
Confidence in that. Okay.
We're hoping to be there completely ready for the next election.
In like the fall of this year. The next election's in 2 years.
That's what I mean. For the next election in 2 years.
Okay, but to reapportion or redistrict or could even consider it, we have to be ready almost immediately following this election. So if this election is June 25th, it has to be before the end of this 2011.
I'll have to check into that one for you.
Okay, would you get back to
Yeah.
me in writing? And I think the whole council would probably appreciate that. Thank you, Madam Speaker.
Ms. Fulbright?
Yes, I have a quick question here concerning Sequoia County. It says pending delivery, like their system is not up and going like it should be, according to the 911 people. I mean, we voted in the county to give them an extra 50 cents on cell phones, and then the county commissioners gave another 50 cents without us voting on it. And according to them, they said they've got everything just so-so, but according to you, that's not right.
They don't have their data to the point where we can actually pinpoint all of our tribal
Okay,
citizens.
I'm going to go meet with them. Thank you. That's what I want to know.
Mr. Justice, can you stand one more minute? Mr. Hoskin had a question.
Well, I just briefly, I don't think I can say it much better than Councilor Cowan Watts said it, but I mean, we do have in the law that we are to redistrict, and so we're really, our original discussions with the administration was to help us adhere to that law by getting this data. So I hope when you report back to us, you'll reassure us that in fact that's where the eyes have been, not on the 2012 election itself, because if that's the case, we may have lost a lot of months here with not us knowing where your all's focus was. But so I just want to reiterate that. I appreciate the work that you do though. Thank you.
Thank you, David, for
Thank you.
being here today. Moving on to old business. First item is the travel expense policy. Since the elected officials' compensation legislation, which isn't effective until next term, unless there's a specific provision that you want to discuss, I will withdraw this particular item. Any provisions you want to bring forward, I'll just withdraw it till next term. Okay, second item is resolution declaring Cherokee We Are Many as the national anthem. Mr. Baker, Joe John Baker.
Yes, everybody should have gotten the words and the music and the disc of this beautiful song, and I put it in form of a motion to pass it as the national anthem.
Can I have a second?
I'll second.
Moved in second. Discussion? Yes, Ms. Coates?
I have no objections to the idea of having a national anthem. I have no objections to the song. It is indeed beautiful. The words are entirely appropriate. My concern is that I think that as a government on a number of levels, on a number of things that we have put forth, we operate on a principle of what we do for one, we do for all. And the fact is, this nation never solicited a national anthem. This was something that was sent to us with that suggestion. And it just seems to me that in fairness, there are probably many musicians and many artists, songwriters and so forth out there in the Cherokee Nation that might also like to have an opportunity to submit a composition for the national anthem. And I think that if we're going to do for one, we need to do for all. If we are considering this person's very lovely composition, we need to consider what other people might have to offer as well. So I would not support this. I would request that the body consider my comments and that perhaps we think about some kind of a call for submissions for the national anthem. And an independent body of some sort, perhaps the committee that works on the National Treasures Awards, but something along those lines to consider, in fairness, the compositions of other Cherokee citizens as well. Thank you.
Any other comments? Seeing none, yes, you support the resolution. All in favor signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Roll call, please. Yes, is you support the resolution.
Janelle Fulbright,
No.
Don Garvin,
No.
Chuck Hoskin Jr.,
Yes.
Tina Glory Jordan,
Yes.
Chris Soap,
No.
Curtis Snell,
Yes.
David Thornton,
No.
Kara Cowan Watts,
Yes.
Bill Englund,
Yes.
Bill John Baker,
Yes.
Jack Baker,
Yes.
Harley Buzzard,
No.
Julia Coates,
No.
Bradley Cobb,
No.
Joe Crittenden,
Yes.
Jody Fishing Hawk, absent, and Meredith Rayleigh.
No.
We have 8 yes and 8 no.
8 yes, 8 no, motion fails for quorum, majority. Okay, item 3, this act establishes procedures and requirements for naming of buildings and facilities. Mr. Hoskin.
Thank you, Madam Speaker. Madam Speaker, the real issue here is whether the council should be a partner with the administration in naming buildings, or whether we should continue on the course of the administration doing it on its own initiative. I think Councilman Thornton made a good point last month when he said, I think his point essentially was that the council could name a building at any time. That's certainly true. What this act would do, it will constrain the executive branch. It would keep the executive branch from naming a building, and then us to have to react to it. In fact, it really puts the people's branch at an unfair advantage. I feel strongly that we should legislate this. I feel strongly that the same reasons that the 50 states and the federal government put into law the naming of buildings is the same reason that we should. It's an important function that the legislative branch ought to be on par with the administration. I have talked to the chief, and I would like to get us into a little discussion, but ultimately I'm going to table this for another month. But to get us into discussion so that anyone that wants to can discuss it, including Paula, I'd like to move for its approval, and ultimately I'll table it for the next month. But at this point, I move for its approval.
Do I have a second?
Second.
Okay, now discussion.
And could I yield to Ms. Ms. Ragsdale to
Not
comment?
yet. Dr.
Oh,
Cobb
okay,
had
I'm
his hand up.
Yield to Ms. Ragsdale.
Ragsdale, you want
We're
Good
following
afternoon,
over.
everyone. Thank you, Madam Chair. Thank you, Mr. Hoskins. I'm not sure what I can add. We discussed last month, and I think in a discussion with the principal chief, he feels very strongly that it should be maybe a policy, so it's not necessary, or he doesn't feel it's necessary to go in, to make it a piece of legislation. I think that it was unintended that you all were not involved, or that it was not presented to you prior to a naming. It just, we have, I can't even think of it, zoning policies in place. We have cultural policies that tie into that. A lot of processes go into a naming of a building. They pull in the history, the historical portions. They take a look at that. There's a lot of departments, a lot of people that are involved in it. Unfortunately, it was not presented to you prior to that. I think the chief agrees with you that a presentation to the tribal council for your review and looking at the history, the value of the cultural piece that's tied into it, et cetera, that's very valuable, and your input is very valued in that process. So a policy that we go through that process, do the research, do the work for you, and present it to you. A recommendation, I think, is the avenue the principal chief prefers.
Mr. Hoskins?
Well, thank you, Madam Speaker. I would dearly love to continue a debate about whether this should be a law versus a policy, because frankly, I think the merits are entirely on the side of the legislative branch enacting this as a matter of law. I would love to hear the explanation as to why this shouldn't be a law, other than it bogs the system down, which I think is not a real concern. What I'm more interested in is making sure the council's involved in naming buildings. So if I have to sacrifice what I think would be prevailing in a debate with the administration on this, then the bigger interest is let's name buildings. But I will say this, the policy has to do certain things. It has to prevent the executive branch from trotting out a name to the public.
Understood.
Before you come to us. It's got to give the council real notice. It can't be, here's the name, and the next day postcards go out. That's not real notice. I'm not saying that happened, but that can't happen under a policy. So it has to have real time targets in it. It has to have real teeth in terms of constraining the executive branch, which I think really illustrates why it needs to be a law, whether it's this chief or some future chief. A policy is the unilateral action of the executive branch, and it can be torn asunder on a whim. A law cannot. But, again, in the interest of working with the administration, I'd move to table this for a month. We'll see what policy comes forward, and maybe that will be what carries the day.
Second. Move to table in a second. All in favor, signify by saying aye.
Aye.
All opposed, same sign. We have tabled it.
Thank you, Madam Chair. Thank you, Ms.
Yes,
Shaw.
thank you. Item 4 is an act requiring elected officials to undergo random drug testing. Mr. Crittenden.
Thank you, Madam Speaker, Madam Chair. As you know, this was on the agenda last month, and we pulled it and to allow for some thoughts and discussions and whatever. Mr. Hoskin submitted some suggestions of his, and I had several comments as I went down the hall after the meeting that day, and it got me to thinking. I'd like to discuss it some today, if it be the will, and so I guess I need to move for approval to see if I can get a second. So I'll do that this time.
Motion,
Okay.
second, now discussion. Oh, Ms. Gordon?
Yes. There's several things I would like to throw out here for a suggestion on your act. One, I would like to see it go to an independent lab, not, since it's elected officials, I think that it needs to be done through an independent laboratory process. I would also like for us to consider splitting the sample or taking an additional sample at the same time, so that if someone has what they believe is a false positive, then they would be allowed to take that second sample to an independent laboratory and have it assessed. The third thing I would like to see is on C, that we possibly consider a hair follicle instead of the urine test, because I understand from just the things I do at the courthouse that the hair, well, now, some of you may not want your limited amount of hair taken, but I understand that is sometimes a more accurate way to keep from getting false positives. The next thing I would like for you to consider is that I don't think anyone should be removed from office unless it's by a vote of the people. We're elected by the people, and I think we should only be removed by the people. And so I'm somewhat at issue with Section D, on that being a basis for a grounds for removal. I don't agree with the drug testing that we currently have for Cherokee Nation, as the first step being that if you get a positive test, you're out the door if you're an employee. I think that we need to be very open to rehabilitation efforts. If someone has a drug problem, we need to be offering methods by which they can correct this problem instead of just saying, you're out of your position. So I don't agree with the current policy. It's just, you're here today, you're gone tomorrow, and I think that we offer rehabilitation to our citizens, so why are we not offering it as a first step to our employees? And certainly, why would we not be offering it as an elected official? Why would we not be offering that help? So I really have a problem with D, that you would use this as grounds for removal. E, y'all all know I don't travel very much, but a lot of you do travel. What if your name comes up for random drug testing and you're on travel status? That could pose a big problem if you're in another state and you get a call, you're to submit to drug testing. Okay, well, those are my concerns.
Yeah, 30 seconds. I'm gonna add 30 seconds to it because this is important.
Oh, thank you, Madam Speaker.
We have 3 minutes per item, so consider everybody else.
I would make a motion that we extend that time, because this is a very important subject.
I just did.
And I think as a body, we can extend it even more than 3 minutes.
How do you want to extend it to?
I would ask that we extend discussion 15 minutes.
Per person.
Well, I think she's doing it for the whole collective issue. 3 minutes for the whole collective issue.
Yeah.
I would ask that it be extended at least to 15 minutes, and let's see where we are then on this subject.
And we want to make that motion.
I guess I would make that in form
Okay, do
of
you have
a
a
motion.
second? Okay, now,
Just so my mind's clear.
she wants to extend the total discussion on each item, is that right?
Well, this item.
This item to 15 minutes.
Okay, thank you, Madam Speaker.
Okay, all in favor of extending on this item to 15 minutes, signify by saying aye.
Aye.
All opposed, same sign.
Aye.
I think the ayes to extend get it. Okay, Ms. Shelley. Mr. Hoskin has the floor.
Thank you, Madam Speaker. Madam Speaker, I've got great respect for Councilman Crittenden, and I think he proposes this in the interest of making a level playing field. What's good for employees should be good for elected officials. I know he's very concerned about drug use, always has been, and this is the latest example of his concern. I happen to be opposed to random drug testing as a general matter in employment. I'm opposed to legislation that would have the executive branch test the other branch. I don't think that's a good approach. It is one approach, but I just don't think it's the one I favor. I offered a substitute, not because I'm in favor of random drug testing, but because I thought I could address some of the concerns that I had when I first read the councilman's draft, and I think some of those concerns, Councilman Jordan, are addressed in this substitute. Ultimately, I can't support an extension of random drug testing because I think the underlying idea is a flawed one for some of the reasons that Councilman Jordan have pointed out. But I just wanted to go on record, Madam Speaker, with my thoughts and to explain why it is I proposed the substitute. It was mainly to address some concerns I had if this were to pass. Thank you, Madam Speaker.
Thank you. Ms. Coates?
I will echo Mr. Hoskins in that I also don't agree with random mandatory drug testing in principle. I think it is an infringement on the civil liberties of individuals. I think that it's placing people in a position of having to prove their innocence. And that is simply not the way that we work in the United States of America or in the Cherokee Nation. I do understand that Mr. Crittenden's intent, I think, was to equalize the situation for tribal counselors along with employees. And I don't have a problem with that idea, but I would suggest that we go in the other direction with it, which is what my act that we will be discussing later today would do. But in terms of this act, I have been informed by Pat Ragsdale in a long conversation with him yesterday that even the federal government does not have such a stringent standard as either the act or the policy on employees or this proposed legislation for elected officials. That this is, in fact, as a legislative act, this would place a more stringent standard on elected officials than it would on employees, because employees, the random mandatory drug testing that is in place at this time is simply a policy. It's not legislated. This would legislate it for elected officials. I agree entirely with Councilor Jordan's comments about the need for people to be able to redeem themselves, to rehabilitate themselves, and to offer that to people. So those are my very, very strenuous objections to this policy and also to the policy that we presently employ on the employees of the nation. And I have been led to believe that the administration may be open to a review of that policy. So I won't support this for these reasons. Thank you.
Okay, thank you. Any other? Oh, Mr. Crittenden, sorry.
Thank you, ma'am. Well, several people have talked to the fairness issue, and that's really where this was targeted toward. And Madam Speaker, you got a copy of a memo or a little note from the chief on this, and I don't know if anybody's read it, or if we all got it or what, but I'd like to read it into the record. Can I do that?
Yeah, because I haven't read it.
Dear Madam Speaker and Councilors, I note with interest the item on today's Rules Committee agenda, which was last month, requiring drug testing for elected officials, and would like to go on record supporting this idea, not only in concept but in practice. Since drug testing of every Cherokee Nation employee was implemented, I have voluntarily included myself, just like every employee, in the pool of staff members who can be randomly selected for testing. I've taken and passed tests since we have implemented this policy. I have not asked our hardworking employees to do something I am unwilling to do, so I welcome the council to join me in taking the same test our employees do and to implement consequences that meet constitutional provisions for elected officials who fail tests. Now, that should not necessarily have anything to do with whether somebody supports this act or not, but again, it's a fairness issue. I don't have any problem with it myself. And I understand some people do from one position or another, and that's okay. If we want to work this and tweak it somewhat, I'd be fine with that. I'd just like for all of us to be equal on this issue, the employees and us as elected officials, because we're leaders, and I think we ought to lead by example. And that's my position. Thank you.
Thank you. Any other questions? Yes.
I don't have any questions, just a little statement that Joe was talking about. I agree with Joe. Of course, I've been in law enforcement for years and years. And as far as I'm concerned and the employees that I've talked to, these employees are in the mind frame of what's good for the goose is good for the gander. So I would like to go in that direction. If it's changing the policy where it's getting so strict on the employees, you know, the same as us, well then I'm for that. I'm for changing the policy for them. Because some of these employees are griping And what they're mainly griping about, some of them are being tested, not randomly, but they know they're going to pass the test, so they give them the test, and they test so many people. So some of these employees have been tested more times, considerably more times than other employees. So I'm kind of with Joe on this deal, but if you want to change the policy to help the people, help our employees, I'd be for that, as long as it's, as we have to consider taking the same test. Thank you.
Thank you. Dr. Cobb?
I would like to echo Councilor Coates and Councilor Hoskin. I'm not in favor of random drug testing, and I do have some experience with that. 25 years ago and 50 pounds ago, when I was a Division I athlete at the University of Kansas and under the auspices of the NCAA, we were tested all the time, sometimes 4 and 5 times a month. I found it invasive then, and I found a pervasive attitude that I was having to prove that I was innocent of something at that time. 40 pounds ago and 10 years ago, when I was an Olympic athlete, and I was under the auspices of the United States Olympic Committee, USADA, which is the drug testing arm of the Olympic Committee, I was drug tested 3 times in 1 week. And they actually came to my office, and I was with a patient, and requested that I come up front, and I said, I'm with the patient, and they said, we don't care. You either get drug tested now or you fail the test. And I found the attitude of I was having to prove that I was innocent of something 10 times worse. So I do have some experience with drug testing, and I'm not in, so I will not be in favor of this. So I just wanted to point that out. Thank you.
Thank you. Ms. Callen Watts and then Ms. Gloria Jordan.
Thank you. I do think this goes beyond the constitutional requirements, and initially I was for it. I didn't see any issue with it. I guess being a non-lawyer, I just thought, well, it's a new rule, we'll set a rule and we'll comply. But once the lawyers and some other folks had started talking to me about the issues and the precedents it sets, I think it does go beyond the employee policy. I think anybody on this council would be happy to have a drug test, and you would hope all of us would pass. But I would like to yield additional time to Dr. Coates.
I think one of the suggestions, and I don't know if Councilor Crittenden would consider this, but one of the suggestions I know that has been considered is that that the council could have pledge cards or something like that, that when we come into office, that to state that we will not use illegal substances of any kind. And I think that, you know, something like that as a policy, I would be entirely in favor of doing something like that. My concern is that if we pass this legislation and then we pass the one that's later on the schedule, we've actually set up a situation where employees are now relieved of this, and the legislative branch is burdened with it, on the other hand. So if the intent truly is to equalize the situation, I wondered if Mr. Crittenden would be open to considering something like I have suggested, which is a pledge on the part of the members of this body now and in the future, and also in support of equalizing the situation with employees, that maybe they do the same, and that the random drug testing on employees, as in the later proposed legislation, would be only on those in certain sensitive and critical professions. So I guess I would offer that maybe as a, it wouldn't exactly be a friendly amendment, because it would be a substitution, I guess, for the act, but if that would be something you might consider.
Ms. Gloria Jordan?
Am I supposed to answer the?
No.
Okay.
Well, I guess I didn't get to finish up last time. What I wanted to say was, I really don't have a problem with random drug testing, but I firmly believe whatever we're going to do should apply to us and employees. It should be consistent. So I guess in a way, Julia, I'm agreeing with what you just said. What I am against is first step is you're out. I think that we need to look at the whole drug testing policy and build in rehab features into that policy instead of just giving up on the people that we have put probably hundreds of thousands of dollars in training for the position that they're in, and then all of a sudden we're just telling them you're down the road. Where if they had been a citizen coming in for help, we would have said, oh yeah, we've got all kinds of rehabilitation programs for you. So why is it that we're sending our employees down the road as the first step? And why would we be sending our public officials elected by the people down the road as a first step? Let's offer rehabilitation for a drug problem if it's found to be a positive testing, and after an appeal process it's still found to be a problem. Let's get them into a rehabilitation program. Even the legal field recognizes in the state of Oklahoma that we have people that have problems, and we offer rehabilitation efforts. We don't say we're going to take your license because this has just happened, you've got a positive test. We say let's get you some help. Now maybe a lot of people don't agree with that, but I don't see it as let's put the monkey on their back, they'll never be able to get a job again. I see it as we need to help our people. And that people extends to this council, it extends to the chief, it extends to the deputy chief, and it should be extended to the employees. But I won't sit here and say I'm not against random drug testing. I've been in positions and jobs all my life where random drug testing was required. I, like Counselor Watts, just assumed when I first looked at it, well, it's probably no problem. I've been in those positions before. I've been tested before. I've been tested several times to just get a job. Been tested several times as federal background checks. I don't mind doing it, but I just see a discrepancy in the drug testing provisions we have now, and I think this is a good time probably to correct it for everybody.
Mr. Creighton, did you want to respond to Ms. Coates' question?
If you want me to, I will.
Yeah.
I think I like, Ms. Coates, I think I kind of look like what was just said, better than a pledge card type thing, because I don't know, a pledge card may work out all right, but I just, personally, I don't have a lot of faith in that, but, and it might be good that, since we're having this discussion, it might be good that we talk about it a little more and then maybe hold off till next month or something, so we can all get on the same page with these ideas and stuff, possibly. But I don't like the pledge card thing. I really don't. Thank you.
Todd, you had waving your hand down.
Yes, Madam Chairman, I believe what has been said has been a very good discussion, and Ms. Coates brings out a good point of that if this were to pass and then later her act passes, then we've kind of flipped the boat, so to speak. And I would agree with Mr. Crittenden that if we wait another month, we could maybe get all on the same page on this. So I would recommend a motion to table, find out how we approach Ms. Coates' act. And I think the idea of everyone here, the consensus is the same, is to make it a level playing field or fairness for elected officials and employees alike, whatever that policy is. So I would recommend tabling this and considering Ms. Coates' act.
Thank you. Mr. Bezer?
Just a comment. I think what Councilor Hoskins has written up is more in line to what I would favor, but from my experience, I've worked here for 24 years and probably had 60 to 80 people under my supervision at one time. And I guarantee you, if you don't have some type of a random drug test, you're going to have people using drugs. I've probably had as many as 4 people that have used drugs. And I don't remember, but I thought the policy here at the Cherokee Nation that we give them a one-time 30-day suspension, and if they come back clean, then they come back and get their job. And I think that's still in place, as far as I know. I'm not disputing this either way, but
your time's up.
Pardon me?
Your time's up.
Well, I just want to say that, I just think something needs to be in place.
Okay, we have a motion on the table to approve this act as written, right, Mr. Crittenden?
Ma'am,
approve this act as written? Are you going to
I'm
table?
gonna table it, if that's allowed.
Have a motion and a second. All in favor, signify by saying aye.
Aye.
All opposed, same time. Motion carries to table.
Madam Chair.
Yes, sir.
Madam Chair, I'd like to add a resolution to new business. This would be honoring Ron Cooper for tribute to Cherokee people in Korea and their steps along the Trail of Tears.
Yeah.
And I'd like to put that in form of motion.
Have a motion to amend the agenda to add this resolution honoring Ron Cooper. Do I have a second?
Second.
Any discussion on amending the agenda? All in favor, signify by saying aye.
Aye.
Opposed, same sign.
Madam Chair,
Yes, sir.
that table was till next month. I didn't say that, but that's what I meant. Is it, can we do that?
Okay, the last item was tabled until next month.
Okay. Thank you.
Item 5,
Madam Speaker, while you're changing the agenda, I'd like to withdraw business item number 7.
withdraw item 7. Okay. A motion to amend to include Mr. Thornton's resolution and also to withdraw Mr. Garden, number 7. All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Okay, item 5 is discussion regarding the administration use of contractors to conduct surveys. Mr. Hoskin, you want to take
He just asked if we do, if I do a motion to table it for another month.
Okay, I have a motion to table, and a second.
Second.
All in favor, signify by saying aye. Aye. All opposed, same sign. What a weak eye. Okay. Under new business, we have item 1, resolution authorizing the choice of law, choice of venue in the Oklahoma Healthcare Authority and Sooner Care General Provider Agreement. Dr. Cobb.
Thank you, Madam Speaker. I think you'll find there was a handout right when we started committee. It's some new language. It says Council of Cherokee Nation. It says resolution expressly authorizing. It's at the top. I think everybody has it.
You're substituting this one, Dr.
Yes.
Cobb?
Yes,
Okay.
ma'am.
Everybody have a copy?
They should. I believe it's handed out. If you don't, raise your hand. So there's
Substituting this one for the one in the book. One under new business. Okay, Dr. Cobb, please.
Essentially, this authorizes the principal chief to negotiate choice of law and choice of venue clause in Medicaid billing between the Cherokee Nation and Oklahoma Healthcare Authority. Essentially, this is going to include, at this point, 3 items within our health system. The first being ambulatory services with Medicaid billing in the amount of $185,000. Eventually, it's going to include clinics and hospitals to the tune of about $26 million. So I would move for approval.
Motion to approve, second. Discussion. Ms. Count-Watts?
Okay, so this new version says that this is not a waiver of sovereign immunity.
My understanding, and please, Mr. Ragsdale, if you need to, I will yield some time to you. My understanding is that this gives the principal chief the authority to negotiate choice of law and venue as far as the venue clause in the Medicaid billing. I will let admin, I'll tell you what, I'll yield to the Secretary of State on sovereign immunity. The depth of your question will probably be better answered here.
So before she answers that, this flies in the face of our relationship, potentially flies in the face of our relationship with the federal government. I think in that if we waive any sovereign immunity to the state of Oklahoma on this, because we should get this money directly, we shouldn't even have to go through the state for this. I mean, and IHS is the payer of last resort by law, which we've contracted for that position.
I'll address those once at a time, if I may. First, the waiver as it goes to our relationship with the federal government. Medicaid as a program is delegated from the feds to the states. These funds flow through the states. If you wish to bill Medicaid and you're any entity, tribal, non-tribal, if you're a provider of healthcare services, you must bill the state in which you reside or those services are provided. We, as a nation, have that situation in many different programs, and CDC is a good example of that. Funds flow directly to the state, and in order to access those funds, we must negotiate with the state in order to access them. That doesn't mean that we don't continually try to change those laws, that we don't lobby, that we don't press to amend those federal laws to get a direct tie to the nation so that those funds can come directly to tribes. That is something that is always on our horizon and that we're going to continue to lobby for. So in terms of this, it is what we must do now in order to access Medicaid funds because there's no other legal avenue to access them at this time. Doesn't mean that we won't continue to try to get legislation that will allow us to do that.
So it is not a waiver of sovereign immunity?
It is a waiver of sovereign immunity, and let me explain why we put that sentence at the bottom of this. It is a limited waiver for selection of law and selection of venue. It does not directly consent for us to be sued, and that is why we put the other sentence in there. And Chrissy can elaborate if you'd like for her to. A waiver must be express, and we are not expressly agreeing to be sued in any court, even though we're agreeing to what law will govern this agreement. So do you want to add to that at all?
I would just say, I don't believe this is a waiver of sovereign immunity. This is just giving chief permission to sign a contract that says it will be governed by federal law in federal court. If they were to try to sue us, we would still argue in federal court that we were immune. The reason that I recommended to help that this come to tribal council because there's some recent case law that says a tribe agreeing to a non-negotiated contract is not a waiver. So on the flip side of that, this is a negotiated contract. They have taken out other provisions. They have changed language for us. And the argument could be from the state of Oklahoma, since you agreed that federal court was a venue and federal law was the ruling law, you've also agreed to be sued. Again, that's something that a court would decide, but it was based on how courts are deciding, it was a close enough issue that I felt that tribal council needed to agree to this law and venue clause. But I do not believe that this in itself is a waiver of immunity.
One last question. So is this typical for other states, or is Oklahoma's new regime the one that's deciding all this?
The case I'm talking about is actually a 10th Circuit case out of Colorado and went to federal court. So it's,
was the tribes involved?
Yes, and it was a different kind of contract, a different issue, but it was. The main issue was that the tribe had agreed to federal court and federal law.
And I just wanted to add that, that this language is specific to tribes in IHS. The state has negotiated away from state law and state jurisdiction over to federal law and federal jurisdiction for the purposes of dealing with tribes in IHS.
Dr. Cobb, were you finished?
Yes, ma'am.
Well, because I think there's some confusion among some of you. We'll extend this for 5 more minutes because I have 4 other people who want to talk. Mr. Garvin.
I just want to make a motion, we turn off our cell phones.
Motion granted. Mr. Jordan.
The only thing that I really haven't understood here so far is that we're dealing with the state of Oklahoma. If we had a sovereign immunity problem come up, it would not go into state court, it would go into federal court. Is that what I'm hearing? Okay, thank you.
Mr. Hoskins, and then Mr. Henry.
Thank you, Madam Speaker. I'm getting a little bit nervous about this. Is it time sensitive?
Melissa?
Yes, the contract actually expired April 30th, and I have gotten them to agree to extend it to June 30th. So
I wonder if the state if the folks on the state side were in the room and we asked them if we were waiving sovereign immunity, they certainly wouldn't say we were expressly waiving it, but I guess they would probably argue the other side of our Attorney General's office.
I'm not
And
sure.
it sounds like it's a debatable question.
I will say, they didn't approach this from a immunity issue. They approached it as we contract with a lot of different tribes, and we're not going to negotiate each individual clause with each individual tribe. So this is something that we think all tribes can agree to. We'll change it to federal law from state law, and we'll change it to federal court from state court, and kind of, this is our last effort to do. So I don't know that it was an immunity discussion and then being able to sue, that we really never even talked about that.
Melissa, on in regard to third-party billing, what's the value of this that you brought forward here?
Almost $27 million.
27 million, so you would have to cut that out of your
Yes.
health budget?
Yes.
Okay. Todd?
Thank you, Madam Chairman. Obviously, yes, there's a significant amount of money involved, and as being lawyers, it's our indicative to point out the potential pitfalls that you may have in an agreement. Anytime you reach into an agreement where you're subjecting yourself to the jurisdiction of another court, it must be taken very seriously. As Ms. Nemo has pointed out, the trend of cases have been to bend over backwards to find waivers of sovereign immunity, and we have experienced that firsthand with the Cossie case, where there was an implied waiver of sovereign immunity and implied consent to the courts of competent jurisdiction, where we ended up being sued in the state of Oklahoma. It is much more palatable that we are going to consent to federal jurisdiction instead of state jurisdiction. That is a big concession, and I'm proud to see that. However, even in federal law, we're going to the federal courts will apply federal procedural law, but still Oklahoma substantive law will prevail. So we still have to be consistent with, or be cognizant of Oklahoma law in these matters. It may very well be that the price tag is too much and the bargaining power is just not there, that we would have to sign it. But we do need, it is indicative of me as your counsel and Ms. Nemo and the Attorney General's office to bring forward these potential issues, because they are real live issues, and it could very well be considered to be an implied waiver of sovereign immunity. Obviously, we would argue against it, and there would be case law on both sides of that. Also, part of this agreement that I just wanted to point out real quick is that it causes for us to comply, or it says, as applicable to Indian tribal governments, provider, which will be the Cherokee Nation, shall comply with and certify compliance with. It reads off a litany of federal acts and the Oklahoma Workers' Compensation Act. Will that be applicable to, will those acts be applicable to Cherokee Nation? I don't know. There are some of those federal acts that specifically exempt Indian tribes. There are some that say that they do. There are some that are silent on there, and obviously the ones that are silent are the most troublesome. There is the Donovan rule. There's a federal court that says that laws of general applicability won't apply to Indian tribes unless it hits 3 factors. I think it just behooves the lawyers for the council and the Attorney General's office to say that, the door may be open on the applicability of those federal acts, and we need to make sure that we can build defenses to them if necessary. I just wanted to make those points clear to the council. But then again, it's a policy decision of whether whether the price tag is absolutely worth it, that you need to pass it. Thank you.
Thank you. And we have a motion on the table to approve this resolution.
Could I, just a point of clarification?
Yes, ma'am.
And I guess I'm going to have to direct this towards Melissa. Melissa, is it my understanding, even though we've got information in here about third-party revenues, that this resolution will only apply to Medicaid billing agreements?
Yes.
Okay, so that's all we're talking about today?
Yes.
Is Medicaid billing agreements?
Yes,
We're
ma'am.
not talking about third-party revenues or Medicare or other insurance resources?
Okay. This is with the Health Care Authority.
Okay, All in favor of this resolution signify by saying aye. Aye. All opposed, same sign. Okay, motion carries. Okay, item 2 is a resolution authorizing the principal chief to negotiate and execute a waiver of service for the Microsoft project. Yes, I have that one. This resolution authorizes the principal chief to execute a limited waiver of sovereignty for a Microsoft language project. The nation and Microsoft have entered into a memorandum of understanding to share certain confidential information and trade secrets to achieve the language project. Due to the sensitivity of the information, the parties desire to enter into a non-disclosure agreement, which is attached and made a part hereof, providing for enforceability. The limitations are that a suit would be limited or extended to an injunction preventing release of confidential information by the Cherokee Nation and to recover actual damages resulting from a breach of the agreement and for reasonable attorney fee and actual costs. As usual, if monetary damages are awarded, the award cannot include real property, trust funds, and cannot be a lien or encumbrance on tribal property. Ms. Knott.
Thank you, Madam Chair. This agreement, I can only speak about it very generally because, of course, we do have a non-disclosure agreement that we're trying to work out. But it is generally to incorporate Cherokee language into Microsoft products that are coming down the line, and we must share various technical information, various information that's not revealable to the public in order to accomplish that. And it's going to be a long-term project. We'll probably see the results of it in approximately 2 to 3 years, but a worthwhile one in terms of having Cherokee language accessible on more products. So that's our interest in doing this.
A motion to approve, do I have a second? Second. Discussion? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Okay, item 3 is an act requiring drug tests for employees to be based on warranted and reasonable suspicion. Ms. Coates.
Madam Speaker, I would ask that the debate on this be extended to 15 minutes once again. That'd be granted. Thank you.
15 minutes.
This is in response to Councilor Crittenden's desire to equalize the situation between employees and elected officials of this nation, which is a goal that I actually do agree with. But this is the direction that I would take it in instead, for reasons that have been stated before, that there is an issue on principle about random mandatory drug testing and placing individuals in the position of having to prove their innocence, which flies in the face of the way that legal matters are conducted in this country. I've stated already my positions that we have a far more stringent standard than even the federal government has in this regard. There's been a handout that's gone around. I hope everybody has gotten it. I don't know if you guys have at the end of the table. I don't see here's one if it can be handed across. And this is data that has been provided by Human Resources, and I want to thank Alana Castillo and Michael Botello and their staff for providing us with this data. But it indicates pretty conclusively that we have a non-existent drug problem essentially here at the Cherokee Nation, and every single year the number of employees that are testing positive is less than 1% or less. And we are spending significant amounts of money to test people for a problem that apparently doesn't exist. And what I want to clarify is that the first number that you see on this of 107, that is a cumulative number or compiled over a period of 5 years. That's not in 1 year of 2006. That's a number between 2002 and 2006. So the numbers are very, 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 very low. They are low, and they are low as a percentage of the workforce. I've already stated that I feel very, very strongly on principle that this is an infringement of civil liberties that we all enjoy in this country. I also, however, think that there are cultural considerations that we have to take into account as an Indian nation. We know that bodily substances are something that very traditional Cherokee people often have beliefs about, and we know this in the medical fields here as well. Even drawing blood and other types of saliva, other types of bodily substances are not things that people from a culturally traditional standpoint want others to have access to or to be handling, and this is something that is very difficult for a segment of our population. And we certainly have that segment of our population working at the Cherokee Nation as well. I also want to address Mr. Buzzard's comments from earlier that if we don't have random mandatory drug testing, that we will have drug use in the workforce, and that's just that. We will have drug use in the workforce whether we have it or whether we don't. That's a reality of our society. But these statistics, this data indicates pretty much that although we do have some, it is very, 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 very minimal. I would guess it's far more minimal than in most workplaces that you would find anywhere in this country. So for these reasons, this act would eliminate the random mandatory drug testing of employees except in certain sensitive and critical occupations, and those would be law enforcement, heavy machinery operation, people who are working in medical professions where they are providing direct medical care to clients, and for those who are working with children. But other than that, people who are doing administrative work, clerical work, landscaping work, if it doesn't involve, all of these professions that really, there's no reason, it seems to me, to be adding to the indignity by requiring random mandatory testing of people who are not exhibiting any reason for that to be imposed on them. Thank you.
I need a motion to approve.
I would move to approve. Thank you.
Second. Do I have a second?
Second.
Okay, now discussion. Mr. Hoskin?
Thank you, Madam Speaker. Madam Speaker, I favor this. I'm troubled by random drug testing just as a general matter. I'm particularly troubled when a government gets in the business of random drug testing. We are an employer, but we have to remember we're a government, and our citizens have certain constitutional rights, and public employment is in a sense different than private employment. And I don't know about the entire federal workforce, but I have some familiarity with some of the federal workforce, and I don't think there's random drug testing going on in a lot of even the federal workforce. I think there's going to be some kind of suspicion that drug use is afoot before we test. That itself can invite some abuse because it's sort of who's going to determine that. But I am troubled by random drug testing of our employees. I'd be in favor of this. I do wonder if we had any statistics of what sort of drug problems we had in the workforce before we had random drug testing. There was a point in time when we didn't have it. And I just wonder if there was some big drug problem and we thought we needed random drug testing or what. Can anyone from the administration speak to the history of this? If Councilor Coates didn't already speak to it, how long has random drug testing been on the books, and do we know what led to it?
Madam Chair?
Sure.
Thank you, Mr. I think we were all throwing around the number. It's 2000, 2001. We began drug testing, random drug testing at the nation.
Do we know whether it was because of, and certainly without naming names, was it a certain spike in drug use, or what was the?
I think it was, I want to say discussion started in insurance, safety checks. It was an accumulation of different things. The HR department, do I have HR here? Anyway, background on testing up on hire had been going on years prior to that. Random drug testing had not. So once someone was on board, it wasn't required for them to do any additional drug testing. So 2000, 2001, off the top of my head, cannot recall. I was here during some of those discussions, but it's just, I'm too old. But it did seem like it was insurance, it was accumulation of different departments, concerns, et cetera, because you've got some of the sensitive areas. So it became that, I think what Counselor Coates had said before, what's fair for one is fair for all. And so it was an approach, I hate to use the term shotgun approach, but it consumed all employees instead of just those targeted ones.
I'm not going to move to table it. It might behoove us to table it so we can get a little bit more on what caused us to get here in the first place.
Sure.
But as a general matter, I am not in favor of random drug testing by the government of its employees. Thank you, Mr. Chairman.
Dr. Cobb? We have 6 minutes, we got 4 people.
A little bit of housekeeping. Section 4, about 3 sentences from the end. I think not shouldn't be in that sentence.
We just saw that and there's, yeah.
Second thing is, you know, I'm just not in favor of random drug testing. I do think this, I applaud the effort of what this is trying to do. It actually is softening the, my concern, and I don't want to put words in Councilor Hoskins' mouth, but reasonable suspicion that the word profiling came to my mind. And, you know, we've had discussions about profiling of Indian people. And on the second page, Part C, the existence of such reasonable suspicion is to be determined by the employee's supervisor. You know, I firmly believe that, you know, HR is doing their job, but that would be profiling based on a personality conflict, and I just don't really, not really in favor of opening that up. So I agree this softens and this moves more toward where I want to go, but, oh, my last thing, and I do apologize, I have a question. This may be for not only in here, but somebody from admin. I have several people that I know engage in peyote ceremonies in Washington County. Yeah, please, somebody answer that. I'd like to know what involves, where that goes.
Dr. Cobb, I'm a member of the Native American Church, and traditional use of peyote during those ceremonies is protected by federal law. Our HR policy recognizes that, so that's not an issue.
That's what I want to know. Thank you, Madam Speaker.
Ms. Fulbright, did you have your hand up, or was that Ms. Fisher? Did you have your hand up? Okay.
How does our insurance do with this? Because I know like ODOT and different people, to keep your insurance from going up, they require a random drug test. Because otherwise you can't afford insurance.
Madam Chair, once again, I think that was some of the beginnings of our discussions about the random drug testing. We had, policy was already in place. You tested upon hire, you know, you went through that process. That's still in place, but then random drug testing, it was some concerns and it was cumulative. It was insurance, I think, some of the sensitive positions, driving, any ODOT, yeah, right. And so it was a cumulative, and it, like I say, it was long drawn out discussion, different departments, this and that was involved. But be happy to get you the history and background on that, how we got from, you know, testing at the beginning to random. The chief has visited with many and concerns about the strictness of the policy. Had in-depth discussion with Counselor Coates. And is willing to look at that again and discuss that policy. So I think that's something that's open for discussion.
Marijuana, how does he feel? Does he think marijuana is okay not to test for? Because it's been stricken through, and marijuana is illegal. Whether anybody wants to say anything or not, it is a drug and it is illegal.
I think if you're talking about the draft that's in the book, that one was from discussion and from some of the information that was provided, and the test showed that I think it was almost zero for any marijuana testing. So I think that was the reason that it wasn't a necessity for the testing.
I think that's, I don't care if there's one person that's the only one getting caught. Marijuana is illegal.
Well, I'm just saying that our results of our test are not indicating that that's a concern. And I think that was the reason for the striking of that provision.
And was he okay with that?
He has not commented on the act. He's, like I said, he's open to discussion about the policy. He subjects himself to the same thing as employees at this point in time. He agrees with many of the concerns Ms. Coates has pointed out. There have been a couple of other counselors that have addressed some issues with him. Mr. Ragsdale has addressed some issues with him. It's something that's just, it's open for discussion. It's being discussed. He has not taken a position on the acts, but he agrees with some of the concerns that you all have.
I want a clarification on this. Section, the existence of such reasonable suspicion is to be determined by the employee supervisor. Who's the chief supervisor?
Cherokee people.
Just a question. Thought came up. I'm just curious. I don't know.
You still have the floor, okay. Mr. Baker?
Ms. Fishing Hawk kind of hit on it. Surely this isn't legalizing marijuana in the Cherokee Nation. Is that what this is?
I'm sorry, Mr. Baker.
Well, when we strike through marijuana as something we test for, are we legalizing marijuana in the Cherokee Nation?
Not in my opinion, I'm not a lawyer, it's not
Yeah,
our
I just don't know why
bill,
you're
and we have not commented on the bill. The principal chief has voluntarily submitted himself, so I'm not sure what the question is.
Well, it says you're striking through marijuana, and I'm saying, are you legalizing marijuana in the Cherokee Nation? That's what it looks like, yes.
It is illegal to have marijuana. It's on the statute book in Title 21.
Why would we not test for it then, if we're testing for anything?
It's a criminal violation to have it on your person.
Well, then
And also, we would not be doing a search and seizure to check and see if a person's on marijuana for criminal purposes. Ingesting it versus having it on your person, it would be invasive to just check to see if someone had marijuana on them for criminal purposes. It is, however, illegal to possess it, traffic in it, sell it.
I guess my question is, why would we strike it as one of the things that they test for?
May I, Madam Chair, Mr. Baker?
As the sponsor of and the one who made the motion, can I?
She has the floor.
Okay.
I have to respond as this is not a bill that has been drafted by the administration. The administration has not taken a position on this bill or Mr. Crittenden's bill. I just have to leave it at that. That is not our bill. We did not write it, strike it. Madam Chair.
Okay, time is up. We have 3 more people to talk, so we'll extend it 5 more minutes, if that's all right with you, Ms. Coates. Okay.
Thank you.
Yeah, you're next. Are you finished, Ms. Gloria Jordan?
Well, I too question why marijuana is struck through, because if we have an employee that tests positive for one of these others, and we have another employee that tests positive for marijuana, they're both illegal. So why are we giving one a pass and one is gonna probably go on down the road? So I can't support it for that very reason. If it's an illegal drug on our books, an illegal drug with the state of Oklahoma where we are presently located, then it needs to be an illegal drug that's tested for under this policy. I too have a real question of whether this will affect our insurance. More and more we're seeing that insurance premiums are based on the willingness of the organization to instill safety features within their policy. And so I believe before we take action on this act that we need to hear from our human resource people or our insurance people that this is not going to in some way infringe upon their ability to get a competitive rate for insurance purposes. The second thing that I'm kind of concerned, well, I am concerned about, is it appears that we're creating 2 classes of employees. One set that's going to be or have to adhere to random drug testing, and another set that's going to get a pass unless we find reasonable suspicion. And that is of a concern to me that we're not treating everyone equally. Again, I would like to see this act, whatever's going to be included for the employees, should also be included for public officials. It ought to all be in one act. Under B, it says there must be a finding that reasonable suspicion exists, and I guess that ties into C. By no means would I support anything where the employee supervisor is going to be the means test for deciding whether someone's exhibiting this unusual behavior. There's just too much play there for someone to take this and use this as a method by which to get rid of an employee that they would like to see go on down the road. The next thing that I have a problem with is let's put some procedures in here where if we have a positive test using only this reasonable suspicion, let's have something in here where the first step is rehab. And I don't see that here. So this is a good work in progress, but I would hope that we're gonna look at it a little harder. So I would make a motion that we table it and work on it again for another month and look and see where we've got by the next month.
I have a motion to table. Do I have a second?
I second it.
I have a second. All in favor, signify by saying aye.
Aye.
All opposed, same sign. Okay, table for 1 month. Okay, item 4 is an act related to amending the Sovereign Immunity Act. This is pretty straightforward amendment. However, Mr. Brad Carson is out of town. He's in D.C. and he asks that we table this until next
That's right,
month.
Madam Speaker.
Table.
So entertain that.
I have a motion and a second to table. All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Item 5 is an act repealing certain gaming legislation. Ms. Countwise.
Move for approval.
Second.
Moved in second. Discussion? Discussion. Now, you want this by acclamation, please? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Item 6 is discussion and action, possible action on constitutionality of previous acts. Ms. Countwise.
I would defer to either Ms. Paula Ragsdale or Ms. Melanie Knight. I believe they have a report for me. Thank you, Madam Speaker. I appreciate the follow-up with it being an agenda item for us.
Thank you, Madam Speaker. As Todd mentioned earlier in the agenda, we've been, since this issue has come forward, we've been researching to see if there are other similarly situated enactments that were still on our books, and also the subject of illegal meetings that occurred during that time period that we talked about in '97. And we found one other enactment that met those criteria, and I'm passing that out for you now. So this would be the second of two. We believe, I believe Todd's research legislative acts, we've included our research extended to resolutions. And I think at this point we're of consensus that these two are the two acts that we need to deal with, or two enactments we need to deal with. This is a resolution that at the time returned law enforcement temporarily to the Bureau of Indian Affairs for a period of 8 weeks. And this occurred in '97. I've attached the minutes of record that show there was not a quorum at this council meeting where this was supposedly passed, and therefore it's not a legitimate resolution. So I guess when I've discussed this with Mr. Hembry, I do see a difference between these two acts and the typical process where we might find part or all of a legislative enactment unconstitutional. These acts, the act in question, the resolution in question, in my opinion, should never have been reflected on the nation's books as having been passed out of a council meeting, because there was not a council meeting. And so should not be. As you can see, it's still in Legistar as being passed. It would be my recommendation, and I don't know what process Todd might recommend, but that something be done via this body to clear the record and remove or basically remove rather than repeal these two enactments from our books.
Are we asking for
Mr.
action?
Hoskin?
Thank you, Madam Speaker. Madam Speaker, this really is duplicative of what Mr. Hembry's already doing. You can look at 10 pieces of legislation that were struck down for whatever reason, and you could pick different bases for which they were struck down. Bottom line is, law was passed, it was deemed to be defective under a constitution. For that reason, it's null and void. Mr. Hembry's already in the process of doing that, and I think this discussion should be tabled indefinitely until he's ready to bring his report forward. He'll certainly use the information that the administration has provided, but with that, Madam Speaker, I'd move to table this discussion indefinitely until such time as Mr. Hembry comes forward with his report. Thank you, Madam Speaker.
Motion to table, do I have a
I
second?
would second that.
All in favor of tabling this item until Mr. Hembry has the, what do you want to add?
Yes, until Mr. Hembry comes forward with his codification report.
Okay. All in favor, signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Roll call. Yes is to table.
Chris Soap,
No.
Curtis Snell,
Yes.
David Thornton,
Yes.
Kara Callan Watts. No. Bill England,
No.
Bill John Baker,
Yes.
Jack Baker.
No.
Harley Buzzard,
No.
Julia Coates. No. Riley Cobb,
No.
Joe Crittenden, Jody Fishinghawk, Meredith Fraley,
No.
Janelle Fulbright. No. Don Garvin,
No.
Chuck Hoskin Jr.,
Yes.
Tina Corey Jordan.
Yes.
We have 5 yes, 10 no, and 2 not in the room.
5 yes, motion fails, so Ms. Watts will continue discussion, and Mr. Hembry, I have you next.
So, if we're going through this
Mr.
confidential
Hembry has the floor.
Oh, I'm sorry, I thought you said Mrs. Watts.
No. No, I didn't.
I will yield time to you. To follow up on what Secretary Knight stated, is that when the principal chief brought this issue forward, and there was a question of a subcommittee, I did an exhaustive research of all the acts that was passed from 95 to 99. The only act that was there, as my report stated, was the one that dealt with the procedures for impeachment of justices. That became void outright with the passage of the adoption of the 1999 Constitution, which I believe under Article 8, the only way to remove a justice is through the Court on the Judiciary. So that act is automatically unconstitutional. As to the resolution is, I did not search resolutions. There's only been this one, but this resolution was for, as all resolutions are, for a temporary character. It had a sunset clause of 8 weeks in it, and it's void by operation as it is. The fact is that just as the last codification procedure occurred, is that there will, at the end of this process, there will be a list of acts that are unconstitutional in the opinion of the codifiers, and acts that are just simply bad policy that we would recommend to the Rules Committee to repeal. And that is the intentions that through my work with Mr. Morton in the Attorney General's office, that's the intentions that we have in this process. We have already flagged this one act as one that is unconstitutional. And the request is going to be a request to repeal it. So therefore, as Mr. Hoskins says, that this process is ongoing, and it will and it will continue to go forward, and it will be the recommendation of the codification group to request its repeal. There would be no reason to repeal the resolution in that it's void by operation in and of itself. But if the body so wanted to take a step, we could move for its repeal also. I would ask that we do this all in one step at the end of it. If we go through the process of piecemealing this, it'd be better, in my opinion, just to do it all at once, because it is to be happening. But as by operation of law, in my opinion, of the passage of the '99 Constitution, the legislative act in question is unconstitutional.
Mr. Henry, Ms. Countwaltz, we only have about 30 seconds. You want to extend this?
I would appreciate like 5 minutes.
5 minutes? Okay, thank you.
But I'm just brief. I appreciate the patience of the committee and our council members. If it is just a question, because I think the '99 constitutional crisis needs to be cleared up. I didn't realize this was still out there, potentially on our books. So if we could just have a report of all of these ridiculous meetings that occurred that were insinuated to be legal, they weren't, the level of detail about who was involved and who wasn't, what they're asserting was law at the time, and if we could just clear this up next month, it would be great. Thank you.
I just want to make a quick comment to respond to an item Mr. Henry raised. As I said before, I don't believe that the constitutionality of a bill here is simply what's at issue. I think it is that there was not a quorum, there was not a valid meeting, and the product of that meeting should not have been reflected on the books to begin with. If a subset of this body were to meet and ostensibly pass a resolution or a legislative act, it would never make it here. And yet this and the other act reflects on our record, our public record, as having been passed. When the public accesses that, it appears to have been passed, but it never should have made it that far. So that would be my comment.
Thank you, Mr. Baker, Jack Baker.
Yes, I make a motion that we remove Resolution 17-97 and Legislative Act 6-97 from our books.
Second.
Moved in second to remove Act 17-97 and 6-97.
Resolution 17-97 and Act 6-97.
Remove those from the books.
Yes.
All right, any discussion? Ms. Laura Jordan?
I would ask Todd to give us some opinion, and he may need to take longer than just here and now, on whether what we're doing may violate our Constitution, because it seems like we're creating something that's retroactive. And I thought our Constitution required us to create no laws that are retroactive.
The normal process for the repeal of a legislative act is just that, is an act repealing a previous act. This council has done this on numerous occasions. The motion to remove from the books there's a Latin term for it, but I don't remember it. It's something like void in operando or something like that. If any other lawyer can help me out, I'd appreciate that.
Nobody else went to Notre Dame, I'm sorry.
There you go. We have a well-learned attorney in the back.
Your AG.
Yes. But no, that is the operation. Is it? And I can't shoot from the hip on it, but would it be retroactive? Well, no law can be retroactive. A piece of law is either constitutional or it's not, and it's either constitutional from its inception or it's not. The basis here is that some 14 years later, do we take action to void out, two pieces of legislation? It's well within the council's purview to do that. But I will just reiterate what the codification process was all about, is that we're in the process of doing that. And this one act, Legislative Act 609, had been flagged for constitutional questionality. And it was going to be, and it is our recommendation that it's unconstitutional and should be repealed. The resolution, if you want to take an action, you're more than welcome. Obviously, you can do that, but it is already void. It has ran its course. It ran its course some 14 years ago after the extension of that 8-week period. But with that being said, it's the will of the body.
I would also like to see the wording of the act that we're attempting to pass now, and we don't have any written wording here that we propose to go on with to the full council. So I ask that this, again, I mean, folks, this is premature. This was...
What action were you asking?
I was asking for the written act that we were going to, that we're talking about passing.
Table this discussion?
Yes, I was going to ask that we table it until we get an act.
Second. All in favor, signify by saying aye.
Aye.
All opposed, same sign. Okay, table till next month, Ms. Jordan.
2 months so that we can give Todd maybe to get this other information on the retroactive part down for us too.
Todd, can you do that?
I can do whatever you ask me to do.
All right, you got it.
Okay. 2 months.
Okay.
Call for question.
I think we
Questioning.
Did
Oh, we voted on it.
tabling it for 2 months?
Yeah, we've already voted on it.
We voted to table.
Table
I
it
don't
for
think
1
the
month.
time frame was given to
Oh,
us
okay,
when
well,
we
I'll just
voted.
leave it vote to table.
Table?
Yeah.
Okay. All lines clear? Okay. For how long?
1 month.
Item 6 is table for 30 days.
No, that wasn't my motion. It was
Oh, I
just, my
thought you
motion was
said-
to table.
Okay, a motion to table. And then Todd, is that automatically 30 days?
A motion to table without a time period on it is a motion to table indefinitely.
Definitely?
Okay.
So somebody has to
So
bring it off the table.
I would put a motion to
So
table.
someone would have to bring it off the table if they want to next month.
Oh, it's
correct?
already been done, yeah.
Yeah, it's already done.
Point of information, I think, yes, technically by Robert's Rules of Order, but the practice of this body is to table to the next month unless it is specified otherwise, either indefinitely or a different period of time. So unless we're gonna go against the practice of the
Okay.
body, it is till next month.
Okay. What I would recommend to the body is this, is that this discussion has been tabled, and there, for the purposes of creating a legislative act to specifically repeal these 2 pieces of legislation. The deadline for rules is when it is, that act of repealing can be brought up at that time or any other time. So the motion to table is fine, and if someone wants to rise it from the table again through this meeting, they can do so. Otherwise, it's tabled indefinitely, but an act to specifically repeal certain acts can be brought during the legislative process.
All right, all minds are clear. We went through item 7. Item 8 is a request to move the Tuesday morning committee meetings and the June 13th, 14th council and committee meetings. Dr. Cobb?
Thank you, Madam Speaker. This is, several requests came up, I think one came up in Health Committee, about moving the Tuesday morning committee meetings to Monday, and to move June 13th and 14th council committee meetings.
To June 20th.
Yeah, to June 20th, is that right? That's what I thought. I don't know if this needs a motion, it's a request. Does this need a motion, or?
Make a motion, I'll second.
Okay.
We're changing meetings.
Well, I figured
Second.
so, but it said request, so I was a little,
I'll second his motion.
okay.
Now, discussion on changing the meeting. Ms. Gloria Jordan?
I was just gonna ask, why are we moving June 13th and 14th?
The council and committee meetings?
Yes, is that a holiday or something?
Mr. Calwatch, you requested that.
National Congress of American Indians is that week, and there's several critical issues for the tribe. So I'm attending as area vice president, and there's other council people I understood were attending as well.
But isn't that why we have where you can come in on the,
Not on full council, though.
That's right, we can't during full council.
well, the
We
only
can on
thing
committee,
is,
but not full council.
June is a really, really busy month for about 8 of us. I mean,
I'm one of
or
those.
maybe no more than that, I guess there might be 10 of us. And I think a lot of meetings are already set in stone during that time. So, I mean, I don't want to take anything away from the importance of the meetings that you have, but about 10 of us also have some meetings that we're trying to attend to during the month of June. So I would ask that it stay where it's at, unless we have a majority of this body that is planning to go to this out-of-state meeting.
So are you requesting a division of the question, or?
Yes, ma'am, that's exactly what I'm requesting. That's a good point.
Okay, President, so we'll take the first item, to move the Tuesday morning committee meetings to Mondays, right? Is that correct?
Yeah, that would be the first part of it, yes, ma'am.
Okay, Mr. Crittenden?
That's just not for next month, that's for on and on, right? Is that what I'm hearing?
My understanding.
Okay.
Everybody's understanding from now on to the end of the term, we remove these from Tuesday to Monday? Okay. I have a motion to do that?
We've had the motion made by Dr. Cobb and seconded by me,
Yeah.
and there's division called on that motion.
So we've already motioned the first thing we're discussing,
All
I
in
believe.
favor of changing the Tuesday to Monday meetings, signify by saying aye.
Aye.
All opposed, same sign?
Aye.
Okay, roll call. Yes, as you want to change Tuesday to Monday.
Bill England,
No.
Bill John Baker,
No.
Jack Baker.
No.
Harley Buzzard,
No.
Julia Coates,
No.
Bradley Cobb,
No.
Joe Crittenden,
No.
Jody Fishinghawk.
No.
There's a
Is that a no?
request.
I'm sorry.
Something about it? What was it?
I didn't hear Jody.
Sorry.
No,
Jody.
sorry. No. Meredith Fraley,
Yes.
Janelle Fulbright,
Yes.
Don Garvin,
Yes.
Chuck Hoskin Jr.,
Yes.
Tina Glory Jordan,
Yes, because it'll help Chuck.
Chris Soap,
No.
Curtis Snell,
Yes.
David Thornton,
Yes.
Kara Callan Watts.
Abstain.
We have 7 yes and 9 no, 1 abstention.
Okay, motion to change Tuesday to Monday fails. Okay, the second part of that is request to move the June 13 and 14 council and committee meetings to when?
Monday, June 20th.
Monday, June 20. Okay.
And 21st, if that's, since that seems to be the flavor of the body, we can just completely move them.
20 and
A week
21st.
later, yes.
Okay.
Please,
All in
thank you.
favor?
Second, or has there been a motion and second? I'd like to offer a friendly amendment.
Yes, he made the motion. I don't remember who, she seconded. Okay, go
Yeah.
Could
ahead.
I offer a friendly that we do it all on one day? We put them all on the Monday for June 20th,
And in the,
For that one
she has
month?
classes in the morning.
for just that 1 month.
Are you saying do them all on June 20?
Yeah, just for that 1 month.
She didn't care.
Yeah, time's up.
Accept it.
Yeah, I'm
I'll
fine
accept
with
it.
it now.
Okay, all in
Yes.
favor, signify by saying aye. Aye. All opposed, same sign.
Aye.
So we
Okay,
did put
roll
them
call.
all.
Point of order, explain that.
Just for you.
Did we put them all in 1 month?
Yeah, she
Okay.
accepted the amendment.
One day.
One day, I'm sorry. Have 30 days.
Okay, roll call.
Joe Crittenden,
No.
Jody Fishing-Hawk,
Yes.
Meredith Fraley,
Yes.
Janelle Fulbright. Yes. Don Garvin,
Yes.
Chuck Hoskin Jr.,
Yes.
Hannah Florrie Jordan,
Yes.
Chris Soap,
No.
Curtis Snell,
No.
David Thornton,
Yes.
Kara Cowan Watts,
Yes.
Bill Anglin, Bill John Baker,
Yes.
Jack Baker,
No.
Harley Buzzard,
Yes.
Julia Coates,
Yes.
Bradley Cobb,
Yes.
we have 12 yes, 4 no, and 1 not in the room.
12 yes, the motion carries to have the council and committee meetings on the 20th.
Thank you.
Thank you. I
So,
guess.
Madam
Okay,
Chair,
item 9.
just to make sure, so that means June, we just have that 1 day? Okay.
On the 20th.
And it's just for that 1 month?
Item 9 is, we're not quite adjourned yet. Item 9 is Mr. Thornton's resolution honoring Ron Cooper. Mr. Thornton?
That's exactly what this is, resolution honoring Ron Cooper for the tribute to the Cherokee people of retracting their steps along the Trail of Tears. Retracing and retracting, and that's wonderful. And I'll make a motion.
Motion.
Second, any discussion? Yes.
I wondered if Mr. Thornton might consider a friendly amendment on the fourth whereas. It says, whereas Ron Cooper is a Native American. I wondered if you would accept a friendly amendment to say Mr. Cooper is a citizen of the federally recognized Comanche Nation, is that correct?
Yes.
Something along those lines, rather than simply the generic Native American.
That's even better.
Okay.
Who's second?
Second's all right.
Okay, everyone clear? All right.
Aye.
All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carried. Okay, any announcements?
Madam Speaker,
Yes.
one clarification. When do we start on the 20th? Do we have a,
Same time we do
1.
roll them all starting at 1?
1 community service, 2 health, 3 education culture, 4 resource,
Make sure.
but health subcommittee.
Can I put an email on that? As long as it's posted 2 weeks before. Thank you.
Okay, any other announcements? Next meeting, May 26th, 1 o'clock.
Motion with adjourned.
Second.
All in favor, signify by saying aye.
Aye.
All opposed, same sign. We are adjourned at